Join former FBI senior forensic examiners Becky Passmore and Stacey Eldridge as they dig into the world of digital forensics, one bite at a time. Now leading their own consulting firms and educating the next generation of cyber sleuths. These badass babes of digital forensics bring sharp insight, real-world case experience, and a dose of humor to the bits and bytes that build today's investigations. From deep dives into business email compromise and ransomware attacks, Becky's specialty, to cracking the complexities of iPhone forensics, Stacey's obsession. This podcast delivers insider knowledge for professionals, students, and true crime techies alike. If you've ever wondered what really happens when the digital trail is all that's left, tune in and start parsing the truth.
Welcome back to Parsing the Truth, One Bite at a Time. I'm Stacey Eldridge, and with me as always is my co-host, Becky Passmore. We're diving into digital evidence that cracks cases wide open. This is true crime with a focus on the facts and the artifacts. Becky, what are we doing tonight?
Well, tonight we have another special guest. We're very excited about Lauren Hillery, and she was the attorney that represented the printed emails in the last episode. So we're very excited about having Lauren on our podcast tonight to talk more through the trial and all the things that happened during the trial. So welcome, Lauren.
Hi. So whether you're a digital forensic examiner or an attorney, we hope you'll find this case as fascinating as we have, and we can't wait to dig in deeper with Lauren. So, Lauren, for our listeners, can you briefly introduce yourself and give us a little bit about your professional background?
Yes. My name's Lauren Hillery. I grew up in Mississippi. I graduated from the University of Mississippi School of Law in 2009. I practiced civil litigation for 10 years out of law school. So that probably had a lot more to do with electronic discovery, digital evidence, probably a lot more than criminal law. But in 2020, I switched to criminal law, became a public defender in Hinds County, Mississippi, which is in Jackson. And that sort of changed my career and my life way for the better.
Yeah.
And so since then, I have been a public defender in Jackson, in Harrison County, which is in Gulfport and Biloxi, Mississippi. And I also was a federal public defender for a time. And so that's sort of an overcap of my professional life. I am currently not practicing law at all because in January, I moved to New Zealand.
So cool.
Yes, very excited to be here. And I will actually start school at the end of this month. In order to get my legal qualifications in New Zealand, I have to take a couple of law school courses and sit for an exam meant for foreign lawyers. So fingers crossed, by the end of the year, I will be qualified as a New Zealand lawyer and hopefully continue to practice criminal law here as well.
Amazing.
That's awesome. Yeah, very cool. All right. So can you now share a brief overview of the case and where we spoke about the printed emails last week? If you just give your overview of this case.
My client, his name is Jeremy. He was charged with, I think, 13 or 14 different criminal counts, essentially accused of sexually molesting his stepdaughter. And in a lot of these cases, it's a he said, she said. And so the thing that made this case a bit different was the emails.
Yeah.
And I typically call her a complaining witness.
Okay.
Don't want to use the term victim because that's a bit pejorative from the defense side. But so when she and her mother went to the police, they actually forwarded the detective these emails, and they were Twitter notification emails. So if somebody sends you a direct message on Twitter, on Facebook, probably on any of these other platforms, in addition to getting the message on that particular platform, it'll typically send you a notification to whatever account you have registered. And so these emails would come from notify@twitter.com, and it would say, this person's Twitter handle has sent you a direct message. And in the body of the email, it would have a brief, like an excerpt of the content of the message. And so that's what they brought to the police station. It was about 60 pages. I don't remember the exact number of the actual messages, but that's all they were. Notification emails from Twitter saying, my client's Twitter handle has sent you a direct message. And they spanned a time period from about May of 2022 until February of 2023. And at the time they went to the police station, this is June of 2023.
Okay. And so as digital forensic examiners, we are, emails, that's part of our bread and butter. And so we're really concerned with the emails. And so we'd like you to really kind of tell us why these emails were so important in the case. So if you can kind of walk through the emails from your perspective as the client's attorney in this case, that would be fascinating.
The emails were going to be used by the state at a future trial to say this is corroboration. This is some independent
Mhm.
evidence that this abuse actually happened. And the content of the emails themselves were not explicit. There was nothing sexual about them necessarily, except there was some innuendo. There were things like wear that dress or come give me a hug, and some of them were sent according to the timestamp of the emails at 2 or 3 o'clock in the morning. So, should these emails come in, it's a good thing for the state to then hang their hat on and say, even if you're not sure about what she said, you have these emails that you can hang your hat on. That's hard evidence that this actually did
Right.
happen. And
Right.
so when I got the case, I said, okay, this is the biggest problem. And then I start thinking about, okay, how are we going to attack this piece of evidence? Because the ultimate goal from my side would be we got to keep these out of trial. The jury absolutely cannot see these.
Right.
Yeah.
And it was all just printed emails, right? Did you
Yes.
as it time went on, did you ever get any electronic versions of the emails or what did you get besides
Okay.
60 printed pages from the first get-go with the police?
Right. So I got the 60 printed pages, and these are PDFs, not even in their native format. They're like, when we get Discover, we get a
Oh,
300-page PDF that's all just been scanned, mishmashed together. And so
yeah.
the emails are a part of that case file, which is kind of fine by me because the poorer quality that the evidence is, the more arguments I have to attack it. Does that
Oh,
make
okay.
sense?
Is
Like,
is that
yeah.
why it's always horrible? I was like, I can barely read this stuff. What is going on?
Yeah, because in my mind, this is the worst piece of evidence to get me against me. I don't want it to be any better. Does that make sense? Like
Yeah.
my job is not to go out and find, the truth. I've got to represent my client. And if I dig and say, I want these in whatever format, electronic, where you can get more information, that's probably not going to be helpful. Right. Typically,
Okay. Because,
sure.
I don't know, Becky and I kind of talked about this. We're like, why were they demanding the electronic emails?
Didn't really want them. And that probably sounds
Okay.
like a very cynical, like, point of view, but it's kind of,
You know what we call it on our show when we talk about these kinds of things is we call it the defense strategies. Because, when it comes to attorneys, you are representing the state or you're representing a client, and you have strategies that work for your client or the state. So, I mean, that makes perfect sense.
yeah.
Don't want anything
Although,
else that you'd have to dig a little deeper into. Yeah.
yeah. And although the state has a little bit of a different obligation,
Mhm.
because they aren't only allowed to get things that are helpful to the prosecution. They also have to get things that are helpful to the defense. There's some constitutional rights involved there. But
Right,
for
right.
us, we don't have any of those kind of obligations because our duty is solely to the client and what's in his best interest.
Yeah.
Okay.
So I think that's sometimes why criminal defense lawyers get a little bit of a bad name because our duty is a bit different and it's not
Sure.
to go out there and find the truth because sometimes a lot of times the truth is not helpful to my
Right.
client, right? So I sort of sat on the issue with the email. I didn't want any more information. I didn't want them to go get a better coffee because what they
Mhm.
did do during their investigation, so they get these PDF or these emails from the complainant and her mom. They issued a search warrant to Twitter for my client's Twitter handle and they got 600 pages of response. It was really difficult to read, but it was there from Twitter, certified by their records custodian, saying, okay, here's all the information on these subscribers. So they were able to definitively say, okay, this is Jeremy's Twitter account because this is his email and IP addresses that it was accessed from, all that kind of stuff.
Yeah.
Then when you get to the DMs, there was not a single DM between Jeremy and the girl. Okay, so to me, that's like, okay, they tried to investigate, they didn't find anything. Best case
Yeah.
scenario right here. I don't want to dig any further. And so I sort of sat on it, waited till a couple weeks before trial, and filed a motion to exclude these based on authentication. Authentication, from a lawyer's perspective, just means there has to be a witness to introduce a document that says this is what it appears to be. So for a photograph, you have somebody that says, yes, this photograph fairly and accurately depicts the scene of the crime as it was at that time. So it's not usually a difficult burden, but you have to have somebody to say, this is real, this is accurate, this is what it looked like. This is what
Okay.
this is an email that I received. But this
So is
case
that
was a
kind
little
of the role of the records custodian? And maybe explain like kind of what that looks like for just people who maybe haven't seen that come back?
yes, yes. And a lot of times we have certified records for these kind of things.
Okay.
You send a search warrant off to Facebook or to Google. They send you something back saying, this is what we have as far as photographs or posts or messages, and I'm going to sign this affidavit saying this is true and accurate. This is real. This is a real document from Facebook, and this is, it's authentic. But we didn't
Gotcha.
have that with these emails because Twitter didn't have any of the direct messages. And so that was kind of my first line of attack, just on a basic authentication. And there are a couple of, I guess, cases in Mississippi dealing with electronic or social media type evidence. So
Oh,
there's
okay.
one line of cases that says, if it's a social media post that purports to be, it's got your picture and your name and it says something really incriminating. In order for that to become admissible, you've got to have something else to say that that person actually wrote it, right? Because anybody can
You
make a
mean you
fake
can't just
account.
have a screenshot of it that's printed out on a piece of paper? Is that what that means?
That's what that means. You have to have something else, whether it's, they had their phone during this time period, or you saw them, or, an IP address. You've got to have something else other than just, hey, this is what it looks like. And so
Gotcha.
that was one line of argument. But I thought this was a little bit different because we don't have direct messages. We have email notifications that,
Mhm.
so I guess nobody testified to this, but when a direct message is sent on Twitter, Twitter then turns that direct message into a notification email through some sort of computer process, right?
Okay.
Right.
Mm-hmm.
And there's another line of Mississippi case law that says when you are dealing with computer generated evidence, you have to have somebody from that company, that provider, to come in and say this is done in a reliable way. The big case, which was actually from our jurisdiction on this issue, it was like a failure to register. People that are sex offenders are not allowed to be in so much of a distance of a church or a playground or whatever. And so to prove that he was living or whatever, that he was too close, they just
Okay.
introduced a Google Map screenshot and said, look, it's too close. It's not 1,500 feet or whatever.
Oh my
And
gosh.
and the appeals court reversed and said, in order to introduce that Google Map measurement, you have to have somebody there for Google to say, this is reliable, this is accurate. A computer generated it, but we do it this way. And that makes it something you can rely on. Because,
Interesting. Interesting. So I guess I
so
have another segue question about like,
yeah,
okay, so the Google map, you just can't print it and prove distance. So you either go to Google or how else would you prove distance? Can you say I drove it with my car, I had a
yes,
yardstick?
yes, easy peasy. Keep it simple.
Okay. See, we're
Wow.
out here thinking all the different technical ways we could do this, and you're like, just get a ruler.
Yeah. There was another case about some kind of GPS data, like maybe it was a
Ooh.
stolen car and the company had some GPS thing installed and they wanted to just offer that on its face without saying, how was this GPS data created? Is this legit? Can it be hacked? Can it be tampered with? All those kind of
Yeah.
things. And so those were sort of our main lines of attack because in my mind, these are not messages. These are computer generated emails created by Twitter sent to her Gmail
Gotcha.
account. So I don't really, without Twitter, in my mind, we couldn't get there.
Oh, gotcha. Okay. Yeah.
And
So,
so
no, go ahead.
and so it evolved. Of course, once I filed a motion, the state then tries to fix the problem, which is another strategy reason why we kind of wait until it's getting closer to time. And so I filed a motion saying these are not authentic. We don't have anything from Twitter. And then within a couple of days, I got what they called a Discord journal. Do you guys know what Discord is?
Mhm.
Yeah.
I had no idea.
Okay.
You're like,
I had to go to some of the young guys in our office.
I
And
was
be
supposed to
like,
say it's young. It's a lot younger generation using Discord. Absolutely.
right.
Mhm.
And so she, in preparing to tell her mom about this alleged abuse, she created a Discord chat or channel or something that was private to her, but she inserted a lot of these email screenshots and then had like commentary below them. So they were calling it like an electronic journal. And so
Okay.
that was the next iteration of what I got, which to me was even more inadmissible because it had screenshots of the
yeah.
messages, commentary, which is clearly hearsay, any of that kind of stuff. But the judge did not go for that. And then, so the second or third iteration, they had the complaining witness just come into the DA's office, log into her Google account, and press print on all the emails from Twitter or with this particular handle. And so at that point, it got worse. It went from 60 pages of emails to about 300 pages of emails, and some of which were a lot more damaging. Some said, "Are you horny? Are you up?" Things that really could not be explained whatsoever.
Right.
But the thing that made it even more interesting, and probably more interesting for y'all, so when I get that 300 pages, man, this is what I was afraid would happen. It's gotten worse. But I compared the 60 pages that we got from the police and the 300 pages from Google, and there's a lot more from the version that she printed out in the DA's office, but they all appeared to be the same. Except in 5 of the emails, the timestamps were just a little bit different. I actually went back and looked at my notes so I could give y'all some more
Yeah.
specifics. I know
Oh,
y'all are into
yeah.
this.
Yeah.
There was one on the version from the police. It was sent at 12:03 a.m. On the Google documents, it was sent at 2:53 a.m.
So it's not even like
a
a time zone issue.
no.
It's totally different times.
3:07 versus 13:10, 11:40 versus 4 minutes after midnight.
Wow.
So I flagged these and was like, look, and by this point, this is a hearing. I think we had the initial hearing on a Wednesday. The judge recessed it, called us back in on Friday, and so it's on Friday before trial's supposed to start on Monday. And I'm
Okay.
saying, look, these don't even have the same time. They're a couple
Right.
minutes apart, 17 minutes apart. This is how we know they're not authentic. Because an email time, whether you print it out, in 2023 or print it out now, they should be the same, right? If it's from your
Right.
Gmail account,
Yeah.
nobody could explain it. So I felt like I was this close to getting them excluded, and then the state moved for a continuance. She said,
Well, and then so did they ask for that continuance? Because we know that the state was it just like an IT guy, or was it like somebody like with our credentials that came in and talked about it?
"Probably somebody with good credentials." So the state
Oh,
asked for
really?
continuance and said,
Okay.
look, what we want to do is go straight to Google, issue a search warrant to them, get those certified documents back from Google instead of, printing out from her account or whatever. But
Okay.
I'm still over here saying, I don't care what Google has to say. I care what Twitter has to say.
Right.
Whatever. Motion granted, defense objections overruled.
Okay.
Case gets continued for them to go and get these records from Google. They go and get the certified records from Google within like 2 days. So they clearly could have done this, in 2023. And here we are
Right.
in March of 2025.
Right.
But the timestamp differences were the same. The Google certified documents did not explain or make up or, in fact, so the Google certified records, once I figured out how to plug it into this program, I don't even remember what kind of program it was. Y'all probably know what it is. But it gave me a ton of data, which is the thing I was afraid of in the beginning. But
Yeah.
one of the things it included was time the email was sent and time the email was received.
Okay. Right.
And on these 5 emails that were messed up, it showed that they were sent before, or they were received before they were ever sent. Yeah.
Okay.
I don't have a clue what this means. I know that I'm going to use it though to say this is not good evidence, right?
Right.
And so the judge had set another hearing on the email in advance of the second trial date. So we could have this hashed out, be ready for trial.
Yeah.
And it's at that hearing, without any kind of notice, that the state says, hey, we have an expert now to testify about these emails and the Google response. And he is a legit expert, I would say. He works for the state attorney general's office.
Oh,
He
okay.
testifies in federal court. I know him. Everybody knows him.
Okay.
He's typically involved in child pornography cases.
Okay.
He makes the copies of the computers and does all that stuff in those kind of cases.
Okay. Okay. So he is definitely digital forensic examiner, does the cases and
Oh, yeah.
things. I don't know why I was thinking it was just help desk dude. Quick, can you come to court and talk about these emails?
Well, I think they called him to try and explain the time differences because the judge seemed she didn't rule on anything at this point, but she seemed troubled by the discrepancy.
Yeah.
And so, but when he came, I don't know why they called him when he came and testified because he basically said, I can't explain it.
Yeah.
And I wrote down, where's his quote? I wrote it down. computers sometimes have things wrong.
Oh, have things
I
wrong.
think we brought that up. I was like, computer makes mistake. Computers
Right.
sometimes make mistakes, I think is what we said on our last
Yeah.
episode.
Yeah.
Yeah, because
That
he gave all this preamble testimony about, well, these time zones, it can be different because sometimes daylight savings, but sometimes
sure.
not. And I was like, I don't care about time zones. We're talking about 17 minutes, 2 minutes, 7 minutes. That's not a
Yeah.
time zone issue. That is,
Well,
That's a
yeah, I
true
wonder if they
discrepancy.
even had him look at
Right.
anything, or they're just like, just come on and talk about emails.
well, that's
Yeah.
what I kind of pitched a fit because they did not give me any notice that there was going to be an
Right.
expert. I think I'm entitled to a little bit of time to get prepared to cross any expert because I don't know anything about computers. Um, and so
Right.
the
So now
judge
you have
did.
to really think on your feet, especially since you're not, you say you're not tech savvy, but I don't know. I think you're doing good with these emails myself.
Yeah, I do too.
Well, the judge actually she recessed the hearing again.
Oh, okay.
Gave me 2 days to prepare for the cross, and in
Oh,
that period
okay.
of time, I called him up and was like, "What's going on with this? You know,
Yeah.
tell me what you know." Because people like you guys, you're not on anybody's side. I've
Okay.
always found computer people to be very fair, and they will tell you exactly what it is. "Hey, you're dead. You may have an argument here." Anything in between. And he was like, "Look, they just asked me to look at the electronic data from Google. I don't really have an explanation for why the times are different, but this does appear to be emails that Google received from the email address notify@twitter.com." And that's all he was really able to say. So in my cross that I had 2 days to prepare for,
Yeah.
I really got to make a lot of hay about, Google can't authenticate Twitter. You can't say how these emails are created. You know, if you send a DM, is a notification email sent immediately? Is there a time lag? How is that created? What's the error rate? How often are these email messages sent when there is no message? I mean, there's a million different things you can say that he can't answer anything to because he doesn't have
Yeah.
anything to do with Twitter. And neither did Google. But alas, the email still came in.
Oh gosh. Wow. All that work and they still came in. Got it.
Yeah.
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 Because, Becky and I were thinking, oh, once you have all the electronic versions, then we can examine the headers and see like all the different hops that they went through. Did they really come from Twitter? Or does it just look like they came from
Yeah. It's
Twitter?
an automated message that, is delayed. Yeah.
All he
Yeah,
was
there's
able to really say was, it appears to have come from a valid Twitter email. That's sort of the most definitive opinion that he was able to
yeah,
give.
yeah. So, but he also said computers sometimes do stuff wrong or get stuff
Yeah.
wrong.
Yeah, computers sometimes have things wrong. I
Sometimes,
should I
yeah,
should put that like in a little plaque underneath the not guilty verdict in this case.
For sure.
there you go. Maybe
So
not a
then
great motto for us, but for you, for sure.
yeah.
Yeah, yeah. But, there are a lot of things that could have been done. I'm not surprised, but I think a better investigation when they got that response back from Twitter. I feel like they should have gone back and said, maybe do we need to change the language in our search warrant? Do we need to change the
Yeah,
dates? What else can we do to make sure that we have the best chance of finding this stuff? Because some of these messages were from a couple months before. I find it hard to believe that they wouldn't still be there if they were real, right?
Yeah.
Um, and so the state made lots of arguments about what, they don't keep direct messages, or if a case is involved in, a crime, or an account is involved in a crime dealing with children, they'll close the account. But there was never anybody there from Twitter to say, the account was closed for this reason, or here's our retention policy. There was nothing like that presented. And if the state had been focused on this, or the investigator had been focused on this, talk to somebody like you guys, they probably could have shored up that stuff back in 2023 when they got the case, instead of trying to fumble around in March of 2025 when it's about to go to trial.
wow. Well, and
Yeah.
that's the thing. You have to do it soonish. I mean, everything only
Yeah.
lives for so long online, and I think everything's getting a shorter and shorter retention period for a wide variety of reasons. But I've also had cases, dealing with stuff with Box and these automated alerts going to NCMEC and stuff like that, and there's no real times. And you asked all these people, and we know a lot of people, and we're part of listservs and stuff, and And you ask, like, well, when do they really send this out? And they're like, nobody knows. Like, and because I guess nobody's gotten like somebody from Twitter, somebody from Box on the stand to explain what the heck is really happening on their servers,
Yeah.
And so everybody just takes some of these timestamps as the end all be all. But you're like, come on, like, how quickly is all this stuff moving? Especially with some of this CSAM stuff. Like, really,
Yeah.
like they just it comes on and they're like, bing, bing, bing. Like, is it really that instantaneous? And I know, like, LinkedIn, right? Like, sometimes I get a notification of a direct message 4 hours later, and then I swear sometimes it's like a day and a half later. So I don't
Mhm.
I don't know what's driving it to tell me via email I have a message from somebody on LinkedIn.
Right.
Wacky stuff.
Which is why you wouldn't rely on those notifications. You wouldn't prosecute a child pornography case based on a NCMEC tip. You actually have to go and get the file or the message or the
Or
video,
the
whatever
evidence,
it is.
right?
Yeah, get the evidence. And they just kind of skip that step. And I think part of it is because of the nature of the case, right? These cases are very, very difficult from the defense perspective to win. They very, very rarely actually go to trial. And in this case, there were 13 counts of different varieties. He was facing, I counted it up one time, multiple life sentences.
Oh,
Mm.
wow.
And so for him to go to trial and put the state to their proof took a lot of courage for him and is not something that happens all the time. So I think they weren't thinking about what's going to happen 2 years from now when I have to answer for this.
Right.
But in the meantime, Jeremy stayed in jail from July of 2023 until April of 2025.
Right?
Wow.
Yeah,
Hmm.
yeah.
Almost
That's not
2
great.
years and
Yeah.
waiting to go to trial for something that he eventually was found not guilty for.
Right, right. And
Wow.
one of the counts was a child exploitation count, which was based on the emails themselves. The allegation was that he was using the Twitter messages to proposition her for sexual
Mhm.
activity. And so these weren't just, corroboration for all of the counts. There was one that was actually based on the emails themselves. And we still didn't get that sort of thorough investigation on the front end.
Because again, it was not an actual email message from his email account to her email account. It was just another Twitter DM notification, right?
Mm.
Right, right. And that's all we ever had. And there wasn't
Wow.
much of an effort to find anything else.
So the state got a digital forensic examiner in this case to speak on behalf of those emails. Did you acquire or get a digital forensic examiner to look into it on your side, or you just questioned the state's witness?
Yeah, just question the state's witness. Like I said, my strategy from the beginning was just to wait until a couple weeks from trial, move to exclude them, and let's see what happened. I can strongly consider just waiting until trial and objecting as they tried to introduce them. That's even riskier. So I decided against that. But no, and the state only got the expert after, we've had multiple motion hearings on these emails, and I brought
Okay.
out the timestamp issue. So even they didn't get one to
Oh,
try and prove up on the front end. It was only
Mhm.
and they did not call that expert at trial. They only called him on the motion hearing to try and get the emails in a motion, a pretrial motion.
Mm.
okay. So it's just to make sure that their evidence got in, they used an
Mhm.
expert for that purpose. Okay, got
Right.
it. Makes
But
sense.
then when we get to trial, the only thing the jury heard was from the people involved in the case and the police officer that said she gave me these emails.
Right.
Probably another mistake that they made that I didn't fully understand was they introduced all three email versions. So the 60 pages from the police, the 300
Mm.
pages that she printed out, and then the certified Google records as well. And so I think it just made it pretty confusing for them. Why do we have three versions of these things? Why aren't they the same? Nobody could really explain anything.
With those versions, the three different versions, other than the time stamps, were there any other discrepancies that you recognized?
Other than there being more the second time around.
Sure.
Yes, there were a lot more the second time around,
Right.
and some
Yeah.
that were more explicit, like I said.
Yeah. Were the more do you recall if, like, the more explicit ones, were they, like, older in time, more recent, or they're just kinda, like, sprinkled throughout?
I could tell you. I have a little if you wanna take a little bit of a let me
Because
see.
we're just always sitting here trying to figure out, like, what the heck is going you know,
Yes.
because like,
Yeah, they were
did
more
she edit
recent.
them? The ones were more
I
recent.
could
Interesting.
never figure out the real answer. Yeah. The
Yeah.
worst ones were from January and February, of
But
2023.
still dates from before she turned in that first batch at the police station?
Oh, yeah. Oh, yeah.
Okay. Okay. Well, I just want to make sure like it wasn't like, oh, these are coming in and he's in jail.
No, the time frame, the emails were from May of 2022 until the end of February 2023. The way she told her story, she stayed up all night compiling her evidence, which was these emails. And I think that's when she created the Discord electronic journal, showed her mom all of that in April of
Mhm.
2023. They waited to go to the police until June. And it's in June where they turned over the 60 pages. But
Gotcha.
yeah, they were out there the whole, arguably out there the whole time. Even
Sure.
even the worst ones that I didn't know about until way, way later.
Gotcha.
So if the state had, because you would have known that they were going to have the expert who testified in the hearing, you would have gotten advance notice, or you should have, that he was going to testify during the trial too. And so he was not on the list at all for during the trial then?
Nope, I did not know he was involved in the case at all until I made argument because it was my motion, so I made argument, and when the state got up to make their argument, they called him as a witness. That's when I knew he was involved in the case in the middle of the
Oh,
motion
okay.
hearing. Now I
Okay.
had seen him out in the audience. Like, what are you doing here? He didn't tell me, but
Surprise!
surprise! Yeah, but I think that's why the judge gave me a couple of days to prepare for that cross.
Gotcha.
But then
Gotcha.
but then that was all he did. He reviewed the Google search warrant
Yeah.
response and said, "I don't know why these are different," and sort of went about his merry way. They would have been a lot better served if they got him involved in the case on the front end. I
Mhm.
Yeah.
imagine he probably would have dug up who knows what because they also had her phone and Jeremy's phone.
Oh,
Um,
yes, the phones. I almost
yeah.
forgot.
And there was no messages, no photos, no videos on either of these phones that were both, they say they were forensically examined by the sheriff's office, not by, I think they plug it in to Cellbrite and do their
Yep.
thing.
Yep. So they were just like, click, click, nothing to see here. But,
Yeah.
Becky and I had been on the case. We might have dug in a little deeper to see, what, why, where sort of situation.
Yeah.
Because,
Yeah. And
Telebrite doesn't necessarily parse everything out. There's still some manual work to be
That needs
done.
to be done.
Yeah.
of course, I know that from the child pornography case that I had in federal court. Like,
Mhm.
you don't just put it in a computer program and say, boop, boop, boop,
You
we're
have to
done.
analyze it. You have to analyze it a
Yeah.
little
Yeah.
bit, right? Dig a
Yeah.
little deeper, correlate some events.
Yeah. And in fairness to the state's expert, I think if he would have been involved in the case, we may have
Sure.
at least had some answers about, where did this come from? If
Right.
they were fabricated, there probably would have been some evidence somewhere of that. If, she also made allegations that he had taken photos and videos of sexual activity, they didn't
Where
find
was
any of that
that?
on his phone. Exactly, that kind of stuff.
Mhm.
And I find it hard to believe that my client was sophisticated enough to delete this kind of stuff,
Mhm.
out of people like y'all's reach.
Right.
So maybe we would have more answers if he were involved on what the real story is because people have asked me about this a lot. Like what do you think the real story is about the emails? I
I
don't have a
know.
clue. I don't understand. I don't know. I don't know.
That's
Well, yeah, because, that's our question. What is the real story? What really happened? Why do
Mhm.
those timestamps not match? And then I guess another sort of what if question, right? So if they had called their expert back during the hearing, do you think during the actual trial, do you think you would have like tried to find an expert to counter it, or you're just going to try to cross him really hard and get him to say that computers make mistakes again or whatever his exact quote was?
Yeah, I think I thought my cross was him was effective because he was able
Okay.
to say, I can't explain how Twitter does any of this.
Yeah.
He's not going to put himself out on a limb and try and explain all
Mm,
the stuff that he's not there to testify about.
yeah.
But I think I just would have rolled with him and made him my witness. Said, look, I don't
Mhm.
know. I don't have any messages to review. I can't tell you whether there was a message. I can't tell you how Twitter sends this message, when they send it, how accurate it is. There was just a ton we could use to poke holes in. This piece of paper doesn't mean anything as far as evidence goes.
So how do you think that impacts the jury when you have an expert up on the stand and you can just get them to say like, no, no, no. When it's like in your favor, like, did you do this? And what about this? And they're like, I don't know, and all that sort of stuff. Like, does it have a big impact? Or if we said a bunch of great stuff, or, the answer is it depends probably, but kind of walk us through that.
I think it has a big impact. The defense side, we don't. So, in order for me to get an expert, I have to go as a public defender. I have to go to the court and ask
Yep.
for money to hire somebody,
Oh,
and I have
okay.
to tell them why I need it. And they're very strict on how much we could pay,
They
and
are.
oh, they better be local, or all that kind of stuff. So we're already at a big disadvantage as compared to the state, who has all the resources, all the people they can call on, and nobody overseeing that, right?
Yeah. Yeah, that's what
And
I kinda
so
say, like, I'm like, the state has or the federal government, whoever it is, has all the time, money, and personnel in the world to do this, and then, like, in cases I've been on, I get 16 hours to figure it all out.
exactly, like, oh, you can have $2,000 for this. Like, what is that going to get me? Yeah. And so in our world, a lot of times the best case scenario is to take that state expert and make them our own, or at least
We
score our
have,
points.
yeah.
And then in closing, we can stand up and say, look, the state called this expert and they put them up there and told you how great and smart they were. And what did they say? They're on our side.
Right. Yeah. Yeah. Which we've learned through doing this podcast that defense has utilized the state's expert witnesses sometimes more effectively than the state has in other trials and cases that we've looked into.
Yeah, I think that's true. And it's easier to cross examine somebody than direct, honestly, because all we have to find is one little thing, or,
Mhm.
one point we can make and sort of turn it around. I have been in cases where the state didn't call the crime lab people and we called them, a DNA
Mhm.
and a serologist. And I thought that was really effective,
Yeah.
Very
although the
nice.
result of the case wasn't good. But to be able to stand up and say, this is a state employee, they work for the crime lab, and they didn't even want you to hear from them. We had to bring them into the courtroom,
Right.
that kind of stuff.
Right.
So we really take advantage of that, especially in closing. You know,
Yeah.
these are cops, and we call them.
And I know we're getting off topic from the emails, but since we have you here, I want to ask you
Yeah.
one more question too, from the lawyerly side of things. And so, when I work for the defense and I get, I'm called on their direct, and then the state or the federal government comes back and does the cross, and they're like, did you do this? And did you do this? And I'm like, no, no. But the reason the answer is it's not my job. So my question is, should I be like, that's not my job? Or put in the no because sort of situation. And obviously I have to say it nicely. I can't be all whiny about it. But that's like my concern. Like, how do I respectfully say, that's not my job. That's your job. You guys should have done it sort of situation. I know like my lawyer should come back and help me recover from that, but sometimes they don't know because I didn't say no because they're just like let it slide in that we didn't do this, that, or the other because maybe they don't know what that means either.
Yes, which definitely happens a lot. Every lawyer's a little bit different, but I
Sure.
love when my witness is on cross and talking as much as they possibly can, because a perfect cross examination question should be a yes or a no, right?
Right.
We don't
Right.
want you talking. When I'm crossing somebody, I'm talking, I'm testifying, right? And so the more that you can say, no, I didn't do that because I wasn't the case, or because I was only hired to do this one small thing. I think that would be the government's job. I think that's brilliant. I would love it. Talk to the lawyer that's
Yeah.
retained you on the case.
Yeah.
Sometimes
Yeah.
people aren't, I can be a little more bombastic than some people can. And
I
it may
like
depend
it.
on your jurisdiction as well. Like in federal court, things are a ton more buttoned up, as you probably know. State court is a little more freewheeling. But yeah, I think the more that you can talk and explain exactly what you did and why, the better.
Yeah. Well, and that's
Mm.
certainly a great tip. Minimally ask your lawyer that you're working with, what do you want me to say when the answer is no, because it's not my job? How do you want me to handle that?
Yeah, yeah. But I like it when they're a smart ass a little bit, especially when, they're likable and the jury's kind of vibing with them.
Yeah.
That comes off really good.
Yeah, and it kind of depends on the first couple of questions you're more conservative, but then even if it's the opposite side, generally you get some sort of rhythm going. Now it could be a very confrontational rhythm the whole
Right.
entire time, but it can also be that
Yeah.
friendly sort of we're just up here doing our jobs,
And in our own business.
Yep.
I would hope. Are you being crossed hostilely a lot? That's kind of crazy for a forensic expert.
Well, like a lot. That's not well. I did have one where I felt it was very hostile, and I did say in one of my answers where I was like, he's like, you just said blah 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 blah, and I was like, no, I did not use
No,
any
I
of
didn't.
those words. I think I was politely. I said, no, I do not believe I used any of those words, and then he was kind of like, well, whatever you said. And I'm like,
Which
hilarious.
may or may not have been on purpose, because when we start talking about technical stuff, lawyers kind of get lost in the weeds. Y'all know that, right?
Yes.
We don't know what we're talking about. That's why we have you to sort of explain it in terms that
Yeah.
everybody can understand. And sometimes the follow-up questions don't make sense, especially to y'all.
Yeah. Yeah. But no, I would say that one was kind of one. And then the other stuff is, it was a long time ago. And I think the only strategy they had back then, because they didn't have the knowledge of the technical and know what to ask us, was to be sort of like aggressive and, da da da. And then, we calmly go back, no or yes. And, it's not the answer they want.
Right,
Because
right.
back then, Becky and I first started, and we were both in the FBI then. The FBI case went to trial, totally had the advantage when it came to digital forensics, in my personal opinion.
Absolutely.
So, the most important question, have you
Oh,
been
yeah.
bungee jumping yet since you've moved to New Zealand?
Yeah.
I have been bungee jumping in New Zealand, but it was on our honeymoon. I haven't been
okay.
yet.
Okay, you
Okay.
haven't done it again. And I know you mentioned that was a while ago, but do you remember which bungees you did?
Yes. We did
Okay.
the Nevis bungee in Queenstown.
Yes.
It's over a gorge. It was insane. Actually, I don't know if I could do it anymore. I'm a lot more scared of heights than I was
That
when I was
one, well, at
younger.
least when I did it, was the highest bungee in the southern hemisphere. Was it
I don't know if it still is or
300?
not.
Is it 300 meters?
No, it can't be
Oh,
300 meters, right?
Oh, no.
We gotta Google this.
I got a picture on my wall. 34 meters.
Yeah.
That would have been huge. 300 meters. That's like 1,000 feet.
But yeah, we did that one. My husband went first, and he did like a big swan dive off the
Yeah.
platform.
Yeah.
And the best I could do was just to fall forward and scream my head off.
Yeah.
I'm not doing it. I'm not. No.
I don't know if I could do it again.
No.
Did you do any other ones, or just the Nevis?
Just the Nevis.
Just the Nevis. Okay. Well,
Okay.
there's I can't remember. You can bungee off of. Isn't there the bridge you can bungee off of in Auckland?
Yes.
I did not do that one. I just did the stuff in Queenstown. Or is it
Queenstown, I think, is like where all the extreme sports are.
Yeah.
But it's all over New Zealand. We tried to go skydiving while we were here, but it was like bad weather and couldn't go up. But
Oh.
I've been skydiving before as well.
Yep.
But we'd like to do that kind of stuff. Glowworm caves in New Zealand, and you can like
Yes.
rappel down into the cave, and there's all sorts of insane things you could do here.
Okay, so you're rappelling in the dark then in the glowworm cave? Because
Correct.
wow. Okay. I did not do that. I didn't know that. I just went like floating down the raft. Or the raft down the river.
That's
There was like
awesome.
an extreme version you could do, which we did. I don't know if I could do that anymore.
Yeah. Well, Lauren, thank you so much for joining us. We've really enjoyed
Yes.
hearing your side, hearing your perspectives, because again, it goes back to when we're speaking through the podcast, we talk about the defense and the prosecution having their own strategies, and just to know that these were your strategies. This was what you were trying to do by not allowing things to come in, and why they were not going to be effective, but they were actually effective with you in the end. So thank you for sharing that.
You're
Yeah.
Do you have
welcome.
do you have anything else to add, like why this case was particularly significant or instructive from your perspective?
Don't know that it was particularly instructive. It was a big one. It was the biggest win of my career by far, I would say. I think I mentioned before these cases are incredibly difficult to win because you do have a young girl that gets up on the witness stand and says, he did all these awful things to me. And then
Mhm.
in this case, you did have emails that said, are you horny? Make a video, wear that dress, all this stuff.
Mhm.
And the jury actually followed the law and applied the burden of proof and the presumption of innocence. And that made me feel good.
Yeah.
Not that I don't think anybody stood there and said, "Oh, he was totally innocent." I'm for sure that nothing happened. I think they weren't sure that anything did happen, and so they reached the only verdict that they could, and that does not always happen in these cases in particular.
Mhm.
And when we did talk to one of the jurors, I believe he was woman afterwards, and particularly asked him about the emails, like, how did you not
Yeah.
convict on this exploitation count when you had emails that said things that rang the bell? And he said, we just were never sure that he actually sent any messages. And so to have a jury of lay people with those facts and that evidence really like critically think about, you know, did they really
Sure.
prove that he did anything was really refreshing instead of saying, he's a child molester, he should go to prison.
Give him
So gave me some faith in the system and I can be pretty cynical.
And
Oh
then you
yeah.
promptly left the country.
Yes, I did.
Go out on a high though.
Yeah, yeah. This was
That's
not the last. This was this trial happened, I think, in March or April of 2025. So I
Okay.
did try a couple after.
Okay.
Some good results, some bad.
goes with the job, right?
Yeah, yeah.
Yeah, of
Always
course.
very proud to stand up and fight for indigent people, marginalized people. And I'm just the kind of person that doesn't like authority. And I love to stand up against the government. And
Sure.
makes me feel very American in doing so. I
Right.
believe in the Bill of Rights and the Constitution. And if
Mhm.
if we don't have people standing up for the defendant, where would we be?
Right.
Mhm.
Exactly. That's part of our justice system, right? Yeah. Yeah. Well, thank you so much, Lauren. We appreciate
Thank
your
you.
time. Until next time, stay safe, stay sharp, and as always, keep parsing the truth one bite at a time.
If you enjoyed this episode, make sure to follow us to get notified the next time a new episode drops. If you can do more, head on over to parsingthetruth.com and donate by clicking on the donate button. Parsing the Truth is a nonprofit organization, and we are raising money to send a new digital forensic examiner to IASIS training next year in Orlando. Thanks.